During a racial profiling case, the Ontario Court of Appeal defined racial profiling as the following. Racial profiling involves the targeting of individual members of a particular racial group on the basis of supposed criminal propensity of the entire group. Creates a negative psychological effect on youth, loss of education, increased criminalization of youth, and promotion of antisocial behavior. To avoid this profiling, a zero-tolerance policy in the Safe Schools Act has been established in schools. Causes lack of trust in major institutions, including the justice system, law enforcement, customs and border control, and the education system. There are many outlets to report victimization. However, many people affected by this issue feel complaints in these places won't be taken seriously or will be used against them. People of Aboriginal ancestry feel personally victimized by racial profiling in Canada. Individuals of racialized communities, whether they are recent arrivals to the country or have lived here for generations, report feeling unequal treatment in comparison to the rest of society, and as a result of their experience with profiling, even after achieving success, they still feel the effects of this issue. Creates negative reflections on one's own community and an unwillingness to be associated with their communities. Diminished will to achieve a status of power in society, resulting in a lack of representation of these communities in key societal institutions. Profiling can cause individuals to change their actions and habits in order to avoid profiling. And these individuals have accepted profiling as a norm that they can do nothing about in their lives. Individuals of racialized communities feel as though their human dignity has been compromised. They have been made to feel like criminals due to their race, color, ethnic origin, religion, or ancestry. During profiling, individuals are subjected to racial slurs and discriminatory comments. After these incidents, individuals feel financially burdened due to legal fees and loss of employment income as a result of their profiling. During incidents of racial profiling, individuals are subjected to unnecessary physical measures, such as strip-searched or frisked, and sustaining injuries due to excessive force. Establishment of a Racial Diversity Secretariat that will report on issues of racism in Ontario annually, provide recommendation of future actions in situations of racial profiling, both privately and publicly, develop public awareness and educational activities on racial profiling. Organizations and institutions that are involved in public safety should monitor their own actions for racial profiling, develop policies and procedures that avoid racial profiling, and educate employees. Organizations or institutions with a proven or alleged history of racial profiling should publicly acknowledge these actions and strive to address these issues in the affected communities. The economic issues and damages from racial profiling should be analyzed in both the private and public sector, demonstrating the financial impacts of racial profiling. All organizations, public or private, who work with the government should mandate a zero-tolerance policy for all employees and staff in relation to racial profiling. Violation of these policies should have severe punishments. Organizations with a history of racial profiling should meet with members of the community on a regular basis to facilitate solutions and avoid future incidents. Establishment of governmental systems in which victims of racial profiling can have a safe and secure way of addressing these issues. Furthermore, all members of the police and of private security should have clearly visible name tags to facilitate addressing incidents of racial profiling. Local communities and police services should strive to educate youth on the rights of citizens. This education will help avoid acts of racial profiling and to educate individuals who have been victimized on their rights. This issue is very controversial because racial profiling has security benefits. However, it is seen as highly unethical and violates the Canadian Charter of Rights and Freedoms. The Charter of Rights and Freedoms says the following. Section 15, subsection 1. Every individual is equal before and under the law, and has the right to the equal protection and equal benefit of the law, without discrimination, and in particular, without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. In late 1994 and early 1995, there were 10 robberies of banks, trust companies, and credit unions in Hamilton, Ontario. Based on the following pieces of evidence, police charged Jason Ricardo Hill, an Aboriginal man, with committing the robberies. The police received a Crime Stoppers tip, which named Mr. Hill as the robber. A police officer believed that he recognized Mr. Hill from the surveillance photo taken in one bank. Mr. Hill was seen approaching and leaving one of the banks close to the time of the robbery. Several witnesses identified Mr. Hill from a photo lineup. Witnesses made statements that the robber was Aboriginal. During their investigation, the police released Mr. Hill's photo to the media and also asked witnesses to identify the robber from a photo lineup of 12 people. Of the 12 people in the lineup, Mr. Hill was the only Aboriginal person. The witnesses, who reported that the robber was Hispanic, picked out Mr. Hill from the photo lineup. While Mr. Hill was in jail, awaiting his trial, 2 similar robberies took place in Hamilton. Additional tips were also given to the police, which named 2 Hispanic suspects, one of whom resembled Mr. Hill in physical appearance. Based on this new information, the police dropped all the robbery charges against Mr. Hill, except for the one where he was seen approaching and leaving the bank close to the time of the robbery. Trial proceeded because 2 bank tellers maintained their identification of Mr. Hill. At the trial, Mr. Hill was convicted of robbery and sentenced to 3 years in prison. Mr. Hill appealed the decision, and the appeal was heard after he had spent 318 days in prison. The Court of Appeal for Ontario ordered a new trial because of the problems with the identification evidence. At the second trial, the surveillance photo was digitally enhanced to show that the robber did not have any facial hair. Since Mr. Hill had a full goatee at the time of the robbery, he was acquitted of the crime. He had spent more than 20 months in prison. After being acquitted of the robbery charge, Mr. Hill took legal action against the Hamilton Wentworth Police, alleging malicious prosecution, negligence in procedures relating to the photo lineup, and breach of the Canadian Charter of Rights and Freedoms. However, after a lengthy trial, Mr. Hill's suit did not succeed. The Hamilton Wentworth Police were dismissed of all claims. Mr. Hill appealed the decision to the Court of Appeal for Ontario. Following the reasoning of the trial judge, the court found that the officers met the required standard of care that was owed to Mr. Hill throughout the investigation. The court found that although the photo lineup of the investigation led to the wrongful conviction of Mr. Hill, it was not set up purposely, nor was it negligent. Like the trial court, the Court of Appeal found that the inclusion of Caucasians in the photo lineup did not create a bias against Mr. Hill, because the other men in the lineup physically resembled Mr. Hill. Mr. Hill appealed the decision to the Supreme Court of Canada. By applying the reasonable standard of care expected of the police officers to Mr. Hill's case, the Supreme Court of Canada found that the Hamilton Wentworth Police acted reasonably throughout the investigation and did not violate their duty to Mr. Hill. The Supreme Court of Canada dismissed Mr. Hill's appeal.